Sir, are we good to go?
Jim, it's up to you. You're the ring.
All right, great. Well, thank you. I just want to make sure we're squared away. Good morning to all of our attendees. My name is Jim Linton. I'm Assistant Dean for Experiential Learning here at Tulane Law School. And it's a pleasure and honor for me to be here. And I have the great pleasure of being able to moderate the Justice in Action panel. We have two very impressive panelists today, and I will introduce them. First, Mr. Kevin Beswick, who is seated right here to my left, who will address you all second. Mr. Beswick received a BS in entomology from University of Massachusetts at Amherst. He worked in the oil industry for 12 years in California and decided on a change of career. I know what that's like. And entered into a dual degree program at Vermont Law School, received his Juris Doctorate and a master's degree in environmental law. He's worked at U.S. EPA Region 4, that office for more than 20 years, and most of his work has involved clerka and bankruptcy. And we're very, very pleased to have him here today. His counterpart today is going to address you, I believe, first, and that's Mr. Jason Barbeau, Counsel, U.S. Department of Justice Environmental Enforcement Section. Mr. Barbeau will address you all first this morning. He's a senior trial attorney at this section. At the U.S. Department of Justice in D.C. He prosecutes federal civil enforcement actions under the Clean Water Act, the Oil Pollution Act, the Clean Air Act, RCRA, CERCLA, and the Outer Continental Shelf Lands Act. And recent cases have involved penalties, injunctive relief, and cost recovery actions for oil spills in the Gulf of Mexico, Texas, Louisiana, and Arkansas, as well as securing the largest penalty in the history of the Clean Air Act. Prior to joining DOJ, he worked as a wilderness ranger for the U.S. Forest Service, an environmental investigator, and a litigator in private practice. He's a graduate of Tulane Law School, yes, and Yale University, and we're also very pleased to have him. And so, without further ado, I will give you Mr. Barbeau. Mr. Barbeau, welcome aboard, and your podium, sir.
Okay, thank you.
Thank you so much.
Thank you, Dean Letton, and thank you to the law school and the conference for inviting us here to speak about a couple of big impact environmental enforcement cases. It's a real pleasure to be back at the law school. I think it was maybe the 6th or 7th annual conference that I helped work on as a student volunteer, and I know how much work goes into putting this together, and as Dean Myers said a few minutes ago, it's a huge effort, and we really appreciate all the effort Jay put into getting us here and everyone else, all the other student volunteers. This presentation is going to be presented in two parts, and I'll start, and I want to give you an overview of the environmental enforcement section where I work, and then also talk about a specific case in particular that I've been working on, a Clean Air Act enforcement case that we just resolved last month, which is the case against the automakers Hyundai and Kia. That was the case where we just resolved it in January. We were looking at the first enforcement case to address the greenhouse gas regulations under EPA's new mobile source regulations, and it did result in the largest penalty in the 45-year history of the Clean Air Act, $100 million, as well as injunctive relief and other mitigation issues. But to start on the Justice Department, I'm a senior attorney in the environmental enforcement section at the Justice Department in Washington, D.C. I prosecute environmental cases under all the environmental protection statutes. Our work is nationwide. We service the nation's environmental lawyers, and so that takes us everywhere to all 50 states and the U.S. territories. My work focuses on the EPA Region 6 area, which is New Mexico, Texas, Louisiana, Arkansas, and Oklahoma. Within the Justice Department, there are multiple litigating divisions. The Environment and Natural Resources Division is one of the larger litigating divisions. That's where the Environmental Enforcement Section is housed. That was created over 100 years ago in 1909. Since then, with the rise of environmental protection statutes in the 70s, there was a special unit called a Pollution Control Section that morphed into the Environmental Enforcement Section in 1980. Within the Environment Division, there's the Enforcement Section, which is the largest section, and then 9 or 10 other sections, including a Wildlife Section, a Defense Section, Appellate, Land Acquisition. Like I said, the enforcement division section is the largest. We have 150 attorneys, which is probably the largest collection of environmental lawyers anywhere. On the one hand, that's impressive. On the other hand, we're representing and covering all 50 states and the territories, so that breaks down to about 3 lawyers per state. So we're stretched pretty thin. We have to prioritize our work and make the most out of the cases that we do take. Our mission's broad. We seek to protect, to enforce the environmental laws, to protect people in the environment in all communities. And I say all communities because the Department of Justice is keenly aware of environmental justice concerns, and it's part of our mission and part of our plan to advance environmental justice concerns in the cases we bring. We believe in the rule of law and the deterrent effect of strong enforcement. The enforcement section is based in Washington, D.C. at DOJ headquarters, but the division has several field offices spread out across the country for strategic purposes. It's also worth noting that we work with the local U.S. attorneys' offices, which are stationed and located in every judicial district in America. So we have ready access to the support of the assistant U.S. attorneys, and we call on them in all of our cases. We work together to bring these cases, and the local U.S. attorneys play varying roles depending on the case and the location. This is just a sample of the types of environmental laws that we deal with. It's pretty much all of the environmental protection statutes. This is just a sample. You'll probably recognize most of these. Some are maybe not as familiar, like the FDCPA is the Federal Debt Collection Procedures Act. That gets into an issue of where defendants will try to shield their money or hide their money through fraudulent conveyances when we go to collect on a cost recovery or a judgment. And so it gets into some tricky financial aspects there. Bankruptcy is another major issue that we deal with a lot, and you may not all be familiar with that, but we have to chase down these companies before they disappear and recover the assets to account for the legacies of pollution that are left behind. That's really a whole topic in itself, and Kevin will talk about some bankruptcy aspects in his part of the presentation. On the right is a sampling of the client agencies that we serve. EPA is certainly our biggest client. They bring us most of the cases. They refer most of the enforcement work to us. But we do represent all federal agencies that have any responsibilities for environmental protection. This is just an example of a typical oil spill that I work on. Spills that I work on, there's multiple actions involved. There's high-stakes litigation. In a lot of cases, there are major pollution events with significant harms to people and the environment. And so you have lots of other components of the case going on around us with potential citizen suits. There could be criminal enforcement, private personal injury suits, FOIA requests coming in, cost recovery claims for victims of oil spills, state enforcement actions. We try and keep tabs on all of those things to make sure we're not missing anything and that we're staying abreast of all the issues that are coming up in the cases to make sure that we can advance the government's position to the fullest. Some of these bubbles here also are cases that we would work on either at the same time or down the road, such as natural resource damage claims. We'll represent the federal trustees in bringing those claims if they're not resolved through a settlement process. Same with cost recovery for the Coast Guard. The Oil Spill Liability Trust Fund will seek reimbursement of the Coast Guard's cost recovery, and if that's not obtained, they'll refer the cases to us to collect. Just as there are multiple actions, there are multiple parties involved, and really the DOJ attorney works in the hub and tries to hold on to all these spokes to keep the case rolling towards settlement or trial. We'll be dealing with all of these different parties as we go along, trying to keep abreast of the issues and stay on top of the case. This is just my cue to move on to the specifics of the Clean Air Act case I want to tell you about. What this is a case against automakers Hyundai and Kia, the Korean companies and their American counterparts. The Attorney General and the Administrator of EPA announced a settlement in November of 2014, and the court approved it in January of 2015. The results, in a nutshell, a $100 million civil penalty, forfeiture of 4.75 million greenhouse gas credits that were improperly claimed by the companies, and that are estimated to be worth about $200 million, and then mandatory corrective measures to try to prevent this from happening again that have been estimated in the range of $50 million. As I said, this is the first case to use the greenhouse gas regulations to get at the pollution control from mobile sources. Here's the nutshell of what the case involved. The sale of cars violated the Clean Air Act because they didn't conform in all material respects to the certificate applications that the companies submitted to EPA. And what the companies did was they used incorrect road load forces to represent the fuel efficiency and the emissions from these cars. The cars were, the practices affected nearly all of the cars in both companies, which all come together under the Hyundai Group. So it's essentially one company that has these different marketing departments and engineering groups. But we focused on the 6 car lines that had the biggest discrepancies that are listed up here. That involved over 1 million cars, 1.1 million cars nationwide. And as part of the case also, our co-plaintiff was the California Air Resources Board. They came in as they have proactive involvement in mobile source pollution control, and they have their own state law causes of action, and they were brought in as a plaintiff in the case as well. To understand how we got to November 2014, we have to go back 2 years. In November of 2012, EPA announced to the public that Hyundai and Kia had misrepresented their fuel economy rates on their window stickers in their cars, on their cars that they had sold for model years 2012 and 2013. EPA had found these discrepancies. The companies didn't proactively disclose them despite numerous consumer complaints about the performance of these vehicles. EPA's Office of Transportation and Air Quality, OTAC, and the National Emissions Laboratory in Ann Arbor, Michigan, conducted their own independent auditing of the vehicles and found significant discrepancies focused on the road load force measures that the companies had reported. In response, the companies apologized. They said it was a procedural error. They lowered their fuel economy rates on their window stickers, and they started a reimbursement program to pay back consumers who had been overpriced for these cars because they didn't perform as advertised and they would cost more to operate. These misrepresentations were particularly bad because the companies had built their image and their marketing campaign on being the leaders in high fuel efficiency in the high fuel efficiency sector. So here's an example of one of their ads. They had the 4x40 marketing campaign that on print and other media, where they said essentially we're better than everyone else because we have 4 car lines that get 40 miles per gallon, which is the magic the magic number right now. And so you have these, and then Kia also had one of their cars at 40 miles per gallon too. It turns out none of their cars get 40 miles per gallon for highway. And so they used this campaign to gain market share, to promote themselves. They had another campaign called the Save the Asterisk campaign, where they said, trust us, 40 means 40. You don't need to read the fine print. You don't need to read the footnote or the asterisk like our competitors. 40 means 40. And again, none of them get 40 miles per gallon. The Kia Soul was probably the worst. They had a 6 mile per gallon drop on their highway numbers. In general, the ones we focused on were between 1 and 6 miles per gallon drop, which correlated to road load forces of substantially higher discrepancies, more in the 15 to 50% discrepancy in their reported road load force to actual, and that translated into these mile per gallon differences. So now we're up to November. We filed the complaint and the settlement on the same day because we had spent 2 years doing intensive research, investigations, interviews, administrative depositions, review of a massive collection of documents from Korea, much of which was in Korean, and then intensive negotiations on numerous technical and legal issues. And that resulted in the settlement that we reached, and we filed in the district court in Washington, D.C. The parties were the United States on behalf of EPA, and I should say that this case is a result of a joint EPA-DOJ effort that involved an incredibly talented and dedicated group of EPA people to help bring this case together and resolve it. The California Air Resources Board came in, as I said, as a state player that is a typical partner in EPA's enforcement cases on the mobile source side. On the defense side, we had the Korean companies, the parent, Hyundai Motor and Kia Motors, and then their American counterparts, as well as the last one, Hatchie, is the technical research group that's based in the U.S. that actually submitted the certificate applications to EPA. So all the research and testing was done in Korea. It was funneled through the American companies, vouched for by these American companies, and submitted as true and accurate to EPA. So all of those defendants were proper parties. They're all essentially part of the same group and involved multiple representatives from Korea and America, as well as multiple lawyers and law firms. The basic legal framework for the violations is that the Section 203 of the Clean Air Act prohibits the sale or other introduction into commerce of new motor vehicles that, unless they're covered by a certificate of conformity. So automakers prepare these applications for certificates based on their model cars. They submit them to EPA. EPA issues a certificate. The only way the cars they end up selling are covered by the certificate is if they conform in all material respects to the design application, the design specs in the applications. So those are sort of the key legal issues. The material conforming in all material respects is what we focused on. And the nonconformity that we looked at was road load force. Road load force is a measure of the internal and external forces that lead to slowing a car down while it's in motion. So those are internal forces like driveline friction, external forces like wind resistance, aerodynamics, and then sort of a combo of tire rolling resistance. It's a little bit car and a little bit road. The road load force numbers that are used are determined through a coast down test where you run a car on a track and you come up with these quadratic equations that lead to coefficients that are numbers that are then plugged into the dynamometer that the cars are put on to measure tailpipe emissions and in turn develop fuel economy ratings. So fairly complicated stuff, but there's a clear process on how to do it, and there are acceptable and unacceptable methods for getting to those numbers. In this case, they understated the road load forces, which meant that they overstated the fuel economy. They said that you could go farther on the same amount of gas than it actually took, and in turn that meant they understated the greenhouse gas emissions because it took more gas to go the same distance, meant they had more tailpipe emissions. Now the greenhouse gas component is new. EPA, this springs from EPA's regulations of mobile sources and greenhouse gases in the 2012, starting with model year 2012. That springs from the Supreme Court's decision in 2007, Massachusetts versus EPA, which led to EPA's finding of endangerment in 2009, proposed regs in 2010, challenged in the Court of Appeals in D.C., and then upheld in 2012. So these regs took effect. All car companies had to meet, it's a ratcheting down of greenhouse gas emissions over time to try to control the CO2 in particular, but the 6 greenhouse gases that were identified. The idea is that if you can get your fleet under the max standards for each year, you can get credit. You can get these greenhouse gas credits, which are worth money for the future, so that as you ratchet down the emissions allotments that are allowed each year, if you're not going to make it, you can cash in some of your credits to go over the limits, and overall you have a net amount of greenhouse gas emissions that will be allowed over time. By overstating the fuel economy and understating the greenhouse gas emissions, they claimed they had reduced their greenhouse gas emissions by over 4 million metric tons, and so they took credit for that. They took those as cash, or not as cash, but as credits that could be converted to cash to sell to other competitors or to use to help them down the road when they may not be able to meet these higher or more stringent greenhouse gas emission limits. So that's why the greenhouse gas component is important. It's both for their future production themselves and as a potential profit in selling the cars down the road or making money through selling their credits down the road. The underlying causes of the violations, these are all, of course, based on our allegations. No judicial findings were made, and so everything I'm speaking to today is based on our allegations in the complaint, which are based on our investigation. But as we alleged, the violations resulted from improper testing and analysis, and that was passed on through the companies to EPA. And that comes in the form of the coast-down testing. So you take these cars and you run them down a track, and you're supposed to run them to deal with issues like headwind and road surface. You run it one way, maybe with a tailwind, and you turn it right around and run it back this way, so you deal with the headwind component too. What they did was cherry pick the results. They took their tailwind runs, and these, like the Kia Soul is one of those box QB cars that looked on paper like it performed like a Porsche. It just cut through the air because it had a tailwind when it's running down the road. Clearly improper, outside of industry standards, not good engineering judgment, improper conduct. Another thing that was discovered was, again, sort of cherry picking or selective use of the data, where they ran the full sets down and back. They may have done multiple tests, and then they picked the best result instead of taking all, say, 5 of them and averaging those results to see what the car is really doing. And a number of other things, but those were the ones that stand out the most. Like I said, that led to discrepancies between reported to EPA and actual of between 14 and 50% on the road load force, which is substantial and material. So the results, again, are that we end up with a penalty, the forfeiture, and the corrective measures. On the penalty, it's the largest in the history of the Clean Air Act. It's $100 million they had to pay within 15 days. They've made that payment. The penalty was apportioned to $93.6 million to the United States and about $6.4 million to the California Air Resources Board. For the forfeiture of the greenhouse gas credits, this was a requirement that they forfeit 4.75 million greenhouse gas credits that they had previously claimed. This is important because it disgorges the wrongful gain that they would have had. It protects the air quality because excess emissions would have occurred in the future when they went to cash those in. The net would have been exceeded, and had this not been detected, we would have ended up with additional greenhouse gas emissions. So that restores the integrity to the greenhouse gas banking and trading program that had just been instituted and is just now underway. And it levels the economic playing field for all the other competitors out there who are trying to achieve the mandatory fuel efficiency standards to take the companies back to deal with the reality of what they're actually doing. On the injunctive relief side, they're required to do protective measures to prevent this from happening again. So we have them reorganizing their emission certification group. Before, the engineers that would be responsible for achieving these ambitious fuel economy rates were the ones who tested to see if they made it or not. Now, there will be an independent internal auditing group that will be separate from the design team, and they will do independent auditing and testing of the vehicles to see if they are actually complying with or meeting the design specs and then reporting them more accurately to EPA. We're also requiring improved management and control of the data through quality assurance programs and other internal audits, and then employee training for everyone who's going to be involved in these coast-down tests and other aspects of the certificate applications. In the meantime, this is going to take a little while to get this whole program in place. In the meantime, they're required to self-audit the model year 2015 and 2016 vehicles in America, blind testing, and then to self-report the results to EPA within a set amount of time. That will, in total, is estimated to cost something like $50 million, and EPA is already getting some of the data that's coming in from the 2015 results. This is a completely informal survey based on my own brain about the importance of deterrence. I believe in it. I think this is a good case that shows strong and fair enforcement of the law. The news about this case spread fast, and it spread around the world, and that's what we need. We believe in the deterrent power of the press, and we need to get the word out, and we need to have people know about this. We've seen it in practice that within the industry, news travels, even if it doesn't make front page news like this case did, there are industry publications and there are networks of industry council that get together and learn about these things and spread the word. But we also need to get the word out to the public, and that's an important part of what we need to be doing, and it's something that we continue to work on, is to get the word out to help deter people from doing the same sorts of things in the future, and to realize that there are serious consequences for misconduct. So in closing, this is we view as a really good outcome for this case. In total, it's valued at about $350 million. It's the first greenhouse gas enforcement case. And so as far as getting out of the blocks, we're on the right track to put teeth in greenhouse gas enforcement. I think that every case I work on, and this case in particular, makes me think of this Margaret Mead statement, because even though I stand here in court as representing the United States of America or the Justice Department or on behalf of EPA, every case always comes back down to just a small group of dedicated people who work really hard to get the work done. And that's what happened in this case, and I think that's probably how your public interest works out as well. So I just wish you all the best of luck in all your environmental protection efforts, and thank you for having me here today.
Thank you, sir. Mr. Beswick.
Will you have questions at the end then?
We are.
My name's Kevin Beswick. Thank everybody for being here. This is loaded. Okay, how do I get this thing to be on the full screen?
Alton, can you help? Yes. Okay.
We're going to go from something, I guess, very new, which is greenhouse gas, to something very old, which is a lot of environmental liabilities that date back in many instances well over 100 years. Okay. In this, the Kerr-McGee-Tronox are interrelated. Kerr-McGee was a company that basically had massive numbers of environmental liabilities. They were involved, you see up here, in uranium mining, thorium processing, creosote and pentachlorophenol wood treating, perchlorate, which is rocket fuel manufacturing, pesticide manufacturing, pigment manufacturing, chemical manufacturing, and probably a number of other things that they were doing out there. It's still, the laundry list is really too long to put on the slide. In addition to their own material, that they're also involved in the oil and gas industry, which is a key to what happened in their bankruptcy. It wasn't enough that they had to make their own messes. They also bought a number of companies all the way up into the 1980s, which had legacy liabilities, which dated back into the 1800s. Wilson and Toomer was a fertilizer manufacturing facility in the South. They had a major facility in Jacksonville. T.J. Moss Tie, we're not exactly sure when they got started, maybe as early as the 1860s, 1870s, definitely by the 1880s. They were a wood-treated creosote company. And American Creosoting, which got started in the early 1900s. Kerr-McGee had a huge number of environmental liabilities. They also had a fairly substantial amount of gas and oil lease assets. So what they did starting in 2002 and kind of in stages, really a big one in 2002 and then the final reorganization in 2005, is that all the liabilities were transferred from Kerr-McGee into a company called Tronox. Tronox was a company that they established. They were in the pigment business dealing with titanium dioxide. And when I say pretty much all the liabilities, all the chemical companies, rocket fuel, all that stuff, the uranium mining went into Tronox. About the only liability that we can find that didn't go into Tronox, believe it or not, was the retirement plan and the health plan for the senior managers who ended up at New Kerr-McGee. Everything else went into Tronox. They were spun off in 2006. Shortly thereafter, the oil and gas assets, which was the only thing that was left, were sold to Anadarko for about $18 billion. The number kind of fluctuates because there were some liabilities associated, so it's between $16 and $18 billion, leaving all the environmental liabilities throughout the United States with Tronox. They did have a kind of an insurance plan, which was kind of designed like some of my insurance plans, which is, it means you can never collect. You can pay your bill every month, but when something happens, the way this thing was structured, they had to expend so much money before they could get any money from Kerr-McGee, there was never a chance that they were going to get any of this money paid back. Ultimately, Tronox files for bankruptcy in 2009. This is a map that was put out by, I believe the DOJ actually did this map initially. This is the environmental sites that Kerr-McGee had throughout the country. It's kind of dominated by the bright green ones. I'd like you to kind of put those out of your mind. Those are gas stations. There's about, I don't know, hundreds of them. Most of the gas stations weren't really a serious problem. The yellow ones are ag chemical. The red ones are creosote facilities. I don't know if you can read that on the slide. The big mess is primarily out in the west where the uranium mining was taking place. But throughout the country, thorium processing in Chicago area, the perchlorate contamination in the Las Vegas area. These are the ones that basically we know about. There's probably another 1,000 that we don't. So on May 12th of 2009, Tronox filed a complaint in the bankruptcy proceeding against Anadarko, which was a fraudulent conveyance. They basically said, you stripped us of all the assets, left us with all the liabilities, and you're not supposed to do that. Ultimately, around that same time, and I can't remember exactly how much after they filed, the U.S. intervened basically in the same case. We, at that time, I work out of Region 4. I do primarily Superfund and bankruptcy work. We had a number of sites that were undergoing remediation that Tronox basically said, we're walking away from. Have a nice day. We're filing for bankruptcy. So the case gets started in 2009. In 2011, the Tronox bankruptcy was resolved. And what we did, and this was something that was pushed very hard by the agency, the DOJ, got involved, and it was obviously, we're very extensive, a lot of work that went into this, is the Tronox paid about $270 million, about $25 million of that was set aside for litigation. The owned property that Tronox had at the time was transferred into an environmental trust. That the remaining money was split based on liabilities and estimated cost associated with those sites. There were like 34 sites and a few gas stations. A little bit of money went into the gas stations. The sites were state lead. Some of them were federal lead. In Region 4, most of them were, I guess the majority were federal lead. And it was anticipated that the 270 or whatever the number was left over would really serve to maintain the status quo with these sites for about 3 to 5 years. Hopefully nothing really nasty break loose, maybe continue some investigations. Some of these cases the sites were, in different stages than others. It was to pay for the administrative cost of the trust, et cetera. That was in 2011. In addition, 88% of the proceeds from the fraudulent conveyance litigation went into the trust. And again, that was allocated by the same numbers. This was done, you wouldn't think that federal agencies would go after each other in certain cases when money is involved, but DOJ decided we're going to hire an independent consultant who's going to rank these sites and evaluate how much each site should get out of this litigation fund, because it's kind of unseemly for the various federal EPA regions to be arguing over costs with each other. The money was to be used to remediate the sites, and the proceeds were to go from the litigation trust into the environmental response trust, if and when the money ever got there. Why a trust? A lot of people at the region, I've been dealing with trusts for about 12 or 15 years now. Some people say, well, why didn't the government just sue them? We have this thing called the Miscellaneous Receipts Act, which basically means that if the federal government sues, like in your case, I assume that money goes to the Treasury. If the U.S. had sued directly, that money would have gone into the Treasury. There wouldn't really have been any way to apply it directly to the cleanup of these sites. So we set up a trust. The trust also have less restrictions on what they can do. For the U.S. EPA, sometimes you're working at a site and say, I wish we could own this piece of property because it would make things a lot easier. It's very difficult for the EPA to buy property. We have to go through the Corps of Engineers. It's a long process. It's expensive. The trust doesn't have to deal with that. All they have to do is get approval generally from the U.S., which is, in this case, the Department of Justice and the EPA. The other thing is that without a trust, these 34 sites after Tronox basically walked away from them would have no owners. And that creates a huge number of problems with site control, with access. The property's just kind of hanging out there. In a couple of cases that we've had, some fool has actually gone in and bought the property or reinstated the corporation which owned the property and says, oh, by the way, I own this property now. And then you say, well, by the way, you own a Superfund site, and we're owed $60 million. Welcome to the party. So the trust avoids all of that sort of thing. I've actually had a trust where we had somebody had foreclosed on the property, and because of the way it worked in Alabama, we could go and get that property back and get that guy out of the way. Now there's a big gap here, and this is my mistake. I think this is something that I tried to put out of my mind, so I put it out of this presentation. But between 2011 and 2013, we weren't sitting on our hands. We were doing a huge amount of discovery. We were doing document production. As you can imagine, we didn't have documents. I don't think we had any documents in foreign languages. I'm not really sure. I don't know. I can't remember exactly how many documents that we had. I know that at Region 4, I had to do document reviews on about 65,000 pages of documents. The EPA is really amazingly efficient at generating paper, reports, studies, investigations, and of course emails by the thousands and thousands. Before you release any of that in discovery, it obviously has to be reviewed, it has to be redacted. It's unbelievably tedious. I think a lot of lawyers think, boy, the courtroom drama is the really big thing, but it's the discovery, for years of discovery and document production. And I know somebody described, the law professor's job for going over the first year papers is reading the same bad short story over and over again. This is kind of the same thing where, you're looking at emails that are going back and forth between two people that maybe don't really get along all that well. It was just unbelievable. But anyhow, ultimately it closed. They had a trial. I want to say it was around 25 days in the Southern District of New York. That happened in June of 2013. The court basically found that old Kerr-McGee fraudulently conveyed assets to new Kerr-McGee to evade its debts, including its liability for environmental cleanup that contaminated sites around the country. In April 3rd of 2014, we reached a settlement. And settlement negotiations had been kind of on and off. They were mostly off because I think that Kerr-McGee and Adaka really didn't think that the U.S. had a case here. I know that there was some initial statements that they had put out and said that, we think we can get out of this for a couple of $100 million. And there was a lot of issues. You had the case, we did this before there was the penalty phase had come in, and there were a lot of issues involving fraudulent conveyance. This was not really an environmental litigation, it was fraudulent conveyance. The penalty in a fraudulent conveyance is the value of what was conveyed. There were some issues that were still kind of out there involving statute of limitations and whether this whole reorganization scheme was one action, which would mean there was no SOL involved, or whether it was multiple, which means some of the earlier transactions, which were much more valuable, would have been excluded in a penalty calculation. So we did settle $5.15 billion. About $4.4 billion went to the environmental claims. And this is the largest environmental enforcement recovery ever by the Department of Justice. And on November 10th, of course, because of the nature of this case and some of the other legal issues that are too complicated to get involved in here, in addition to going through the bankruptcy case, it had to be approved by the district court for the Southern District. They did that on November 10th of 2014. It was announced the deadline for appeals passed on January 20th of 2015, and there was no appeals that were filed. So it went into effect on January 21st pursuant to the settlement agreement. They paid $5.15 billion plus $65 million in interest. It's amazing, even at low interest rates, the interest on $5 billion is quite a bit. So that was all paid into the litigation trust on January 23rd of this year. About 85% of the proceeds have been transferred now from the litigation trust to the various trusts that are going to actually do the environmental or fund the environmental work. There's still some questions about, I think, primarily now with the state of New York, is this taxable money that we can get our fingers into. So what's next? This has been going on for 5 or 6 years. It's now time to start doing the cleanup. This is a great little graphic I got. This is a Playmobil set. I guess you're supposed to buy your kids to get them involved. And I actually, when I stole this off the internet a number of years ago, I probably should have gone out and bought it because evidently it wasn't very long lived. And the last I saw, they're quite valuable on eBay. These are the trust sites that were initially receiving funds. I think this is like the 34 sites plus or minus. Some of these are extremely valuable, expensive sites. Theodore in the East Coast, Theodore, Alabama is one of the big ones. Jacksonville, Savannah. Some of them are smaller. The Birmingham's a relatively small facility. Columbus, Mississippi, Meridian, Nevada, North Carolina. But these are kind of the major sites that are receiving funding from the trust. In Region 4, we have Columbus, Mississippi, which is on the NPL, Nevada, which is North Carolina on the NPL, Jacksonville, Meridian. And these are where we just got the money, so we've been working with a trustee. We've set up the groundwork in these communities. There's been a lot of community involvement, and now, like it's kind of boots on the ground. We're going to go in there and actually really start being able to do some major work. There's 2 state lead sites. Mobile, Alabama is actually Theodore, Alabama. It's a synthetic rutile manufacturing facility, which basically was the titanium dioxide facility. And Savannah, Georgia was also a titanium dioxide facility. Just to give you kind of an idea of what some of these sites look like, it's not always just the mess that got dumped on the ground. This is actually the Theodore facility. And any of these facilities that were operating at the time, which when we took over, at least in Region 4, was this one and one in Savannah, there'd been a lot of deferred maintenance, so they just kind of walked away and left all this. So in addition to the environmental cleanup, the trust is going to be responsible for bringing this property back, hopefully into some useful, beneficial use. My experience with sites like this, I imagine there's a fair amount of asbestos up in those pipes, so it's not going to be easy or cheap. The real issue here is iron oxide contaminated with naturally occurring radioactive material in some major settling ponds that is slowly leaking into Mobile Bay. But in addition to dealing with that, you have to deal with the former infrastructure. This is an aerial view of a site in Columbus, Mississippi. This was a wood treating facility. This is probably the early 1970s, and it looks pretty good. And then you go and talk to the folks that worked there back then, and they said, "Oh yeah, anytime we had a spill, we just threw fresh dirt on top of it." So, and you've got these roads look nice and clean and everything, but we know that there's creosote, massive amounts of creosote that are underlying that site. This is another wood treating facility, probably same time frame, early 70s. This one is in Meridian. This is actually a chip shot from Interstate 20. Again, you've got stacks of lumber, you've got the treatment facility, you've got steam boilers, you've got creosote everywhere, and it's a pretty miserable substance they have to deal with. This is a shot of the Navassa facility, and I don't really know the time frame. This is actually scanned from a photograph, probably late 40s, early 1950s. I'm just guessing. You can see the steam blowdowns that are going off to the left side of the photograph. Those are direct blowdowns that are coming out of the pressure treatment cylinders. And in addition to steam, it's also carrying creosote, and it's getting blown into this kind of a marsh area, which is now we're calling a treatment pond. That's going to be one of the first things that we address out there. This is a artist picture of the Wilson and Toomer Fertilizer Company in Jacksonville. These things, there's a lot of legacy environmental liabilities involved in fertilizer in the southeast. They manufactured phosphate using sulfuric acid to treat phosphate rock. That generates a couple of waste streams, one of which is that they used pyrite ore to generate the sulfur to manufacture the sulfuric acid because they couldn't really transport it back in this time frame. That pyrite contained a lot of arsenic and contained a lot of lead. So these facilities generally have arsenic and lead contamination. In some cases, because of the phosphate, they may have some radioactive contamination. And if there are any spills that were made, you've got sulfuric acid in the groundwater, which in some cases, one of the sites I've worked on in Charleston, we have groundwater with a pH of about 2, which is right on a river and a tidal pool that's being flushed twice a day, and the pH in that tidal pool is still around 3.5. This is probably the biggest tragedy, I think, in Kerr-McGee, which was the uranium mining in the Navajo Nation. This photograph dates from 1953. They used the Navajos to do the mining pretty extensively. A lot of the waste rock that came out of these facilities was used to build corrals for the Navajo sheep. It was also used to build structures for them to sleep in when they were out there on watching the animals. And that material is radioactive, and it should all be cleaned up. But it's just such a massive amount of work out there that this area is probably one that there's going to be a funding shortfall because it's just so big. And to clean up all the mining, to clean up all the residue from the mining in the Navajo Nation is allocated about $1 billion. A couple of things I just wanted to bring up before we go into any questions and answers is that litigation is costly and time consuming. And it's even more costly and time consuming when it's a big case. These cases don't come along, thankfully, I think, all that often. I've worked on this one. I worked on another one about 12 years ago, W.R. Grace, that ran a mine in Libby, Montana that's pretty infamous, that generated a huge amount of asbestos. That was nowhere near this big. It was a big case at the time. But, it's, like I say, the amount of time, the number of people that were involved, the Department of Justice, I think, had 4 or 5 attorneys that were working on it. The Southern District of New York had a couple of attorneys. We had attorneys in pretty much all of the EPA-affected regions, which I think it was pretty much all of them. There may have been one region that wasn't terribly involved, but I think we were all pretty much involved. The discovery, document review, it's just incredibly time-consuming. And again, there's no guarantee of winning. One of the sites that we had worked with, we had people that were really critical of the agency because they felt that we should have gone and gotten a lot more money from Kerr-McGee. They felt, for a number of reasons, and they had, I think, some fairly good reasons for feeling that we should have. But the way this case was structured, there was significant risk going forward to try to litigate a settlement number here. And we felt that at the level that we got the $5 billion, $5.15 billion, that the pretty much most all of the environmental liabilities could be handled. And to give you an idea, this for the Jacksonville site, we're going to get $90 million. Navassa is going to get $90 million. Columbus is going to get, I think, about $80 million. The Meridian site is going to get about $26 million. And those numbers are all kind of within our projections and what it's going to cost to address the contamination out there. Again, big cases are rare. And the other thing, too, and you get the press gets the big cases, but the small cases can be pretty important to somebody. And this is a picture that this was a site in Social Circle, Georgia, which was a fairly extensive soil removal. But to where these big sites may get a national attention, these little sites here, these people were dislocated. They had to be relocated. They spent a couple of nights at a hotel where the property got cleaned up. And ultimately, we deal a lot in Superfund. We deal with the public very directly. I think much more directly than a lot of the other programs do. Like I said, most programs don't go up, knock on somebody's door, and say, "I'm from the EPA. We're going to dig up your yard." So just keep in mind that you might not be working with a big case, but the smaller cases can be pretty important to the individuals that you're dealing with. That's I don't know if these materials are available, but this the first one is the kind of a summary of the bankruptcy, and you're probably better off just Google it, and you can find it easier. The second one is the major press release from the Department of Justice. Thank you.
Gentlemen, first of all, let me say on behalf of the law school, and I think all of our grateful citizens, thank you for your service to us, for the country. Thank you for being here and making this panel possible. Before I default to throwing out some questions, which I hope will be pretty relevant and for you all, I think let's take. I think we already have at least one question from one of the audience participants. Ma'am, could you just tell us what's your question? Who'd like to direct it to?
I would like to direct it to the Department of Justice, and actually, it's two parts. But
Mr. Barbeau.
Mr. Barbeau.
Yes.
My name is Ricky Ott. I have a project called Alert, and this is the second question that came up just at the end.
Can you speak up a little?
Yes.
Thank you.
So the second part is that my team has uncovered what we think is a potential Superfund site in Cortez, Colorado, and I would love a contact with the Department of Justice. We've written a little report. We're working with a Navajo, and I'd like to get that information to you. But the question is, have you noticed any tendencies? I mean, do you treat U.S. car manufacturers the same as foreign car manufacturers? Is it easier to target foreign companies and not point fingers at U.S. car manufacturers? What have U.S. car manufacturers learned from this case that how can we be preemptive in the 4x40 so that consumers are really like buying 40 when they think they are? How do we get ahead of this?
Right, that's a good question.
Sorry, I got my voice again. Is that
Perfect.
okay?
Thank you. That's a good question. I had the same question.
Thank you, and I would like to talk to you afterwards about the Colorado site.
So let's get together. On the American versus foreign automakers, I don't think there's a difference in our enforcement view. Since this case broke, a couple of other companies have come in, either self-reported, it's been in the news, I think. American and foreign companies have come in saying they've found some discrepancies of their own, and they're meeting with EPA right now trying to get ahead of it before they get into the same kind of trouble. So that's one of the indicators that this is useful and working. I think that you can have, again, you can take each case as it comes in, and this one was more egregious than most. The EPA's Office of Transportation and Air Quality did audit cars across the spectrum of foreign and domestic cars and found that Hyundai and Kia were just disproportionately out of whack, and it's not a industry-wide problem, at least on these initial looks. It was really, this is a real outlier, and they needed to be targeted for this kind of enforcement. The EPA can't check everybody, and this OTAC group, they have something like, they do maybe 10 to 15% of all cars each year are audited on their own, and they just, working with the resources they have, that some are blind tests and some are based on targeted audits from complaints, from consumers or what have you. But it doesn't, at least the initial information is that it's not a across the industry sort of practice. This was just a real aberration that needed to be caught and controlled.
Congratulations, by the way.
Thank you. And you may actually be, I don't know if the gentleman in the back has a question for Mr. Barbeau or
Mr. Barbeau would be
Mr. Burke?
fine, although I believe either panelist could discuss it. And this isn't really limited to mobile sources, but when a company self-reports, are the fines somewhat, and penalties somewhat ameliorated at that point from their proactive coming forward and basically turning themselves in?
It depends on all the other factors involved in the case. Under the Clean Air Act penalty scheme as well as the Clean Water Act, there are 6 or 8 penalty factors that we look at to decide what the appropriate penalty is. And one of them is an effort to mitigate the violation or good faith efforts to comply, I think is the way the Clean Air Act provision is set up. So that's a factor that comes into play when we think about what the appropriate penalty is. But it's hard to say across the board how that would play out on any given case.
Can I follow up with one?
Sure.
And I suppose this is somewhat subjective, but as a policy criteria, wouldn't we want to give them at least some reduction for coming forward? If they turn themselves in and they're going to be hit just as hard as if you had gone out and discovered and prosecuted, where's the incentive for them to self-report?
Right,
It
no,
seems like we want.
Right, that makes sense. And even, the settling early versus going to trial, you don't get a deal if we take you to trial, you're going to get a deal for early. And that fits into that same thinking about coming in, being proactive, or is similar to settling early. It's certainly something we would take into account, and it does make a difference.
Mr. Smith?
This could be for either participant, but I'm struck by some of the pictures in the EPA presentation as well as some of the discussions that have gone on about land subsidence here in Louisiana, about the fact that many of these events occurred 100 years ago, or in the case of the phosphate facilities, what was it, 1880s? And I'm not a lawyer. I may be the only one in the room that's not a lawyer. But the question is, what happens when companies acquire a company or a site in good faith and suddenly find themselves, like the fellow you all suggested, owning a contaminated site, and the contamination occurred at a time when there was no law governing that contamination?
Under Superfund, there's no real protection. I mean, you're liable, a current owner of a property that's contaminated is liable. There have been some changes in the last couple of years that can give a buyer some protection if they do appropriate, it's called all appropriate inquiry, or they need to go and do a phase 1, phase 2. They need to go through a number of different processes to inspect the property, and they can avoid Superfund liability. They also have to be cooperative if the agency is involved in working at the site or granting access to the site. So the harsh instances in the past where it didn't matter when the contamination occurred, it didn't matter who bought it, it didn't matter when you bought it, you were liable, is ameliorated a little bit. And that, I think, has some a good point to it. It may encourage somebody to go out there and buy property and redevelop the property if they do it correctly. On the other hand, there's some case law where an entity thought that they had followed all of the rules, that had jumped through all of the hoops, did what they were supposed to do, and the court ruled that no, they didn't, that they had caused more contamination at the site or moved the contamination around, and they were held to be liable. It's just the way the Superfund basically works, and the long-term liabilities for especially large companies. You talk about the biggest one that I'm aware of here recently was ExxonMobil. Mobil picked up a huge number of former fertilizer manufacturing sites that in some cases dated back to the 1870s, 1880s. And when Exxon purchased them, they took on those liabilities. And they have been relatively cooperative in cleaning them up. So unfortunately, that's how it's going to work.
Well, I guess my follow-up would be, in the case of Bassett here in New Orleans, we have they're the administrators for the Continental Shelf. They have a policy on plugging and abandonment that if the current owner can't pay, they can go right up the title chain to the original holder of the lease. Is there anything similar to that in this onshore?
For Superfund, the main liable parties is going to be the current owner and the owner at time of contamination. So,
So that gets to your point, the people who were involved, the companies who were involved way back when, they were entities that were part of the disposal of hazardous substances.
Well, for example, Kerr-McGee was the owner of the property, and yet you end up collecting from Anadarko. And Kerr-McGee arguably bought the liability from somebody else who no longer exists.
well, Kerr-McGee had a lot of their own liabilities as well. I mean, they weren't just buying property that was contaminated; they were contaminating quite a bit of their own. And actually, the way the case came out was that New Kerr-McGee became a subsidiary of Anadarko. Anadarko was actually dismissed from the case, and Kerr-McGee ended up being the party that had to pay the money to disgorge some of the $18 billion that they got from the sale.
And that's really honoring the corporate form, right? You're buying the other company, you're taking the good, you take the bad with it. And so really, I think playing through this process is respecting the corporate form that you have acquired another company and merged it into your own.
Well, some of these would have had some sort of a positive affirmation that the sites weren't contaminated. I mean, I could see where, I know I've seen cases blow up where people were buying brownfield sites to redevelop for chemical manufacturing. And part of the transaction agreement was that that site was clean. If there was any contamination, the liability for that remained with the seller. Is that an enforceable position to take?
That doesn't bind the government. That's an indemnity from the other company. That's the way that works. So the current owner can always go back against people who sold to him.
As an
That's
example,
a separate transaction.
Buyer beware, really.
Trying to follow back the transactions can be unbelievably complicated. I mean, there's just all kinds of sales. But in the Jacksonville site, the Wilson and Toomer facility ultimately was bought by a company called Plymouth Cordage. And Plymouth Cordage in the late 1890s was the largest manufacturer of rope for ships in the world. They're in Plymouth, Massachusetts. Plymouth Cordage ended up becoming a company called Emhart. Emhart ended up being bought by a company called Black & Decker. Black & Decker is on the hook for that Jacksonville property because of transactions that can date back into the 1930s.
Would you allow me a comment on this due diligence question? Because you understand the current construct. If you're a purchaser and you exercise due diligence, you're out of the liability. That wasn't always the case, but it is now. But understand what the due diligence requirement now effectuates throughout the country. All real estate sales are now going to be conducted with potential liability in mind. Therefore, due diligence takes place. Therefore, the buyer is, before she purchases, going to have that land surveyed for the toxicity and the possible liability. That surfaces the beast. If without due diligence, that stuff can remain wasted and leaking and contaminated forever. So what the due diligence does is it reveals, the market reveals it. And so that's a salutary effect of it.
But Ollie, what the issue I'm talking about here in Louisiana, the LED, Economic Development Agency for the state, has a tremendous effort going on to redevelop brownfield sites, particularly in light of all of the new construction that's going on, and saying, look, this site may not be the cleanest in the world, but we think it can be utilized for industry and will not make it.
That's handled in the process because the process then goes on with the determination of what remedial level should take place. But that's all part of the process. You know, they don't have to clean it to kid playground eating the dirt standards. That's, nobody's requiring that.
But who's determining? It's that EPA working with the
EPA.
state?
It could be the EPA, it could be the state agency, depending on who's involved with it. With the brownfields, it's generally the states.
But then could EPA come in and countermand the decision? You know, you decide that the site shouldn't have been redeveloped.
That's
I
pretty
don't
rare.
think-
They would
yeah.
say it can be redeveloped, but it needs to be cleaned to this standard or protected in the following way. I think you're imagining a kind of Stalinistic EPA iron boot, and I think that's too strong. I think what EPA is very in favor of brownfield reconstruction. They've got a whole brownfield initiative. So they're on the side of brownfield redevelopment. They just want continuing liability.
I think it would have to be
You're
a
not watching
really,
enough Fox News.
My bad.
it'd have to be a really egregious situation, I think, before, you know, the state would want to, or the EPA would want to jump in on a site that was being handled by the state.
Hopefully, I'm sorry, go ahead. Hopefully I have the sequence right. We have two questions over here, the gentleman in the front and then the gentleman in the back.
My question is for Mr. Bravo regarding the settlement. It sounds like $350 million is a huge, and I guess it's one of the largest that you've gotten. But I wonder if you could talk about how you arrive at that. Because if you just do the division of the numbers that you showed us, 100 million cars, it's $350 a car. And I understand that, you know, there's all sorts of forces in the country that probably would have thought the damages should have been $1. But I wonder how do you determine that how nationally all of this pollution, how do you arrive at a value for that, and how does it really become punitive when you're talking about, well, now we're punishing you $350 per car? You see what I'm getting at?
Right. I mean, it's a tough calculation to do, and it comes from weighing all the different statutory penalty factors. So we look at the seriousness of the violation, offset by their efforts to comply versus the economic ability to pay, whatever the 6 factors are, goes into looking at that. We look at progressing this effort to enforce greenhouse gases, gas regulations. We look at the litigation risk between settling now, locking this in, versus trying it for 5 years. There are a host of things. I can't really talk about what we specifically decided and how we went about doing that, but we balance, just like the courts would in setting a penalty, all of the different factors and look for a fair and just outcome. When you look at this penalty as being multiples larger than any other Clean Air Act penalty before it, that was another gauge that this is, you know, on the right track towards making meaningful enforcement. I guess the other point is that the EPA has its own penalty policy calculations and guidance that's publicly available. And in the mobile source context, there's a recognition that sometimes these mistakes or errors or misrepresentations, they play out because of the nature of the industry of making cars. One error can be compounded 1 million times. And so the penalty policy recognizes a recognition that when you have these high volume for the same underlying conduct, that's not appropriate to penalize everyone the same. And so there is something built into the system, sort of a discount for volume in the mobile source context that we have to deal with as well. So it was never a statutory max times the number of cars, because sure, that could be billions of dollars, and that's just not a way that this case was setting up to play out. I mean, had we gone to trial, we would have a different number, I'm sure, but settlements are compromises, and we viewed this as a fair and strong enforcement under the circumstances.
If I can follow up, I understand that. So is there a calculation on how much damage was caused by this?
Well, so we know the amount of excess emissions that would have been generated. A big part of this case is that we caught them before they used those credits. So that's stripped away. We disgorged a key thing is disgorging their economic gain. Took that away from the penalty does that, as well as taking away those credits they claimed. Knowing they're doing a reimbursement program to pay back all the consumers they hurt, that's a factor that a court would certainly consider, and we considered that as well. Disgorging the wrongful gain is an essential part of coming up with a fair penalty, and that was addressed in multiple ways as the facts played out in this case.
Mr. Beswick, do you need to add to that, or
I deal in Superfund, so we don't usually deal with penalties. We're not really a regulatory statute, we're an enforcement statute. But I think that, I have worked in other cases where you're dealing with an EPA penalty policy that will, set up, the severity of violation, how much harm is it doing to the statute, how much harm is it doing to the environment, how much was it violated, et cetera, et
Well,
cetera.
the injunctive part of it isn't punitive. Are you concerned at all that, it seems to me that the injunctive part of it is pretty much self-controlling by them? I mean, I don't, if I'm hearing it right, what you said, it's that they will take steps and it's self-reporting results.
We can't be everywhere. I mean, we can't have inspectors in all the factories to make sure that we're double checking them. And a lot of what EPA does is based on self-reporting. I mean, we are hopeful, I think, that people will be truthful. And the cases that I've worked in peripherally have generally been with wastewater treatment plants. You go up there, and a friend of mine will do the inspection, they look at the lab results, and people say, well, something's wrong here. Okay, is the person who was turning this information in an idiot, which in many cases they are, they just don't know what they're doing, or is this an attempt to violate the Clean Water Act? We had one person who just couldn't keep track of dates. He'd be reporting, sampling data on days when there was no flow. He just was not competent to be doing the job he was doing. There was no evil intent there. On the other hand, we have cases where somebody is faking the data when they're not running the plant up to standards. They're discharging in higher levels than they're supposed to be legally, and we usually catch them. And they'll be paying for that penalty. And in many cases, especially in those cases, then one of the questions that the moderator had was what the difference between civil and criminal. Then it steps over the line in criminal.
Yeah, this entire regulatory scheme depends on corporations being honest, good corporate citizens, because, like I said, OTAC can audit 10 to 15% of the cars that come out. Everybody is self-reporting on their certificate applications. This whole system works that way. There isn't an EPA that's big enough to catch everybody's conduct, and no one would want that either. And so much of this depends on corporations being responsible, citizens, and doing their part. And EPA checks up on it, and when we find bad conduct, we try to make an example out of it to make a difference, to try to deter others from not doing the same thing. And that's just the way this works in a limited resources, limited government approach to regulating massive industry.
Gentleman in the back there.
Yeah, Mr. Beswick, 2 of the 34 sites that you listed are in Louisiana, one in Calhoun and one in Bossier City. Who's responsible for those cleanups? How much money is attached to each of those sites? And what about American Creosote sites that were not included on that list?
I'm not familiar with sites in this region. I'd have to go back and dig up that information. It should be available online as to what the distribution was for all of those sites.
Where?
If you want to give me contact information, I can get it to you.
Right.
But they were allocated a percentage based on what this consulting company felt they were. I believe that those are both wood treated sites. I have to go back to that slide. So what was the second? Oh, the American Creosote?
Yeah.
Most of the American Creosote sites that I'm aware of were not associated with Turkey, and I believe that for the most part there are no successes. I know the one that I'm working on in Mississippi is a funnel leak cleanup, just recently pretty much completed.
We had someone over here in the middle that had a question. We not. Okay, well then, oh yes ma'am.
I have a question. This might be for both of you, and it might not be, I'm not a legal person, but I sit in the room with lawyers sometimes. And I was wondering, when the state is the lead on a remediation site, it's my understanding they're typically getting money from EPA or whoever is responsible. If that money is going to that state agency and the agency is responsible to spend it on that project, what if that money gets taken up through rerouted, maybe, perhaps, by the administration or to fund maybe budget gaps.
Yeah, I mean,
Is there any, like, check on that? Is there any way that could...
they wouldn't do that. They never states it. That's one of the,
I won't tell you who I work
really, I live in Atlanta, and for years, the tipping fees at the landfill was supposed to have been going to supporting our environmental agency, and every year the government just takes a little and pay half of your money. And that's one of the keys here to the trust. The trust is a fiduciary. The beneficiaries are the state and the federal government. So the money is not going to the state. Now, I have to say that there's been some inquiries lately from the state saying, gee, we got $90 million here. How can we get our fingers into what you can't?
Right.
So in that instance, with the trust set up, they can't do that. That money's with the trust. It's not with the feds. It's not with the state. And if it's a state lien, then the state can direct the trustee to spend the money to clean up the site, but they can't say to the trustee, slide us a couple of million to cover something else. I mean, the number one, that would potentially put the trustee go to jail for breach of fiduciary duty. And I'm sure the first thing that they'd be doing would be they'd be on the phone to the Department of Justice saying, hey, the state or whatever is trying to pull something here. We can't do this. So I think that's a good part of the setup of the trust.
Okay, thank you.
Yes, sir.
First of all, just a timing question. We have a 15-minute holdover period here if people need to filter out now, and that's fine. I do have a question I'd like to pose, though, but not everyone has to stay for it. It's to Kevin, and it's twofold. The first is, it seems to me that actually, this one is to Justin as well. Jason, were there any and with these transactions, these were fraud-based in both cases. How do you decide not to pursue a fraud criminally? I don't understand why this is simple criminal fraud. And the second is, how in the world, Kevin, do you clean up a uranium-contaminated site in the West? I mean, what does that cleanup look like? What do you do?
Well, taking your second question first, I think that most of these mining sites are problematic. The ones that we have in the East tend to be small. The problems are similar. The ones that we have in the West tend to be massive. You're trying to protect two things. A lot of these ores have high levels of sulfur. In contact with water, it's going to generate sulfuric acid, so you try to cap it. You can try to take all of the ore or the waste rock that's laying around a particular site. There may be a pit there. You may put it back in the pit. You may try to put a cap over it to keep the water out. You may have a liner. You have a liner in the pit. We've done that at a couple of mining sites, gold mining sites and other mining sites in Region 4. I think the similar thing would be working out west, probably on a larger basis. But it's difficult, to put the genie back in the bottle. I mean, you let this stuff out, it's all over the place. But really, trying to gather all that material up, put it in one landfill, properly managed, would probably be the way to do it.
Do you live near there?
I don't know how close I would want to be. I think that the issues in the desert are a little bit different. You have probably things like the acid mine drainage that we have in the east. We probably have more issues of contaminated groundwater because of the acid mine drainage that we have, just because of a wetter environment. And I actually, when I was going to school at Vermont Law School, and talking about due diligence, I didn't realize it until after I moved in. The house that I was living in was actually on property owned by the Elizabeth Mine, which is now a Superfund site in Vermont. It was primarily a copper mine that dated back into the colonial times. So I did live fairly close to the Superfund site when I was in law school.
Let me back off the second crim question. It's just, it takes us too far into another area. Let me back down. Thank you.
Yes, ma'am.
On the Kerr-McGee Trust, Does it address human health? Can the trust address human health, especially there's surrounding communities, and there are people who work there, and outreach on education and letting them know about the vulnerabilities and those kind of risks?
Good question.
Yeah, we at all of the sites that we have in Region 4, we have a community relations program that is set up. We also have various grants that go to the community. We keep changing the acronyms for it, but it's community assistant grants, and there's a couple of other different similar type grants. It's for the community to go hire their own expert and have their own expert explain to them what's going on, so they don't feel like they're being, some of the communities, and one community in particular we're working with, frankly, like I say, they have some pretty major grievances, which are probably quite justified in some cases, but we have to try to build the trust with the community. We can help do that with these community grants and bringing in, us paying for an outsider, or the grant paying for an outsider to come in and deal with the community. Human health issues at these sites are generally dealt with studies by ATSDR. I'm not familiar if you're familiar with that acronym. It's Agency for Toxics Disease Registry. They do community studies. They're mandated to do a community study at any site that's on the national priorities list. It's hard to go back and look at what happened in the past because all these facilities have been closed. Generally, I think into the latest one's probably open in the 80s. So you can go out there and look what the health conditions are right now, but you can't recreate what was going on 30, 40 years ago. They have done some studies, mortality studies, infant mortality studies, stillbirths, that kind of thing. ATSDR has done it and looked at those and can present the data. But again, you can't really tell what the historical effect was from these facilities, except probably in the uranium mines where you've got such a long latency for health issues associated with radioactivity.
And if I could, I'm sorry.
Just a follow-up on the Theodore plant itself, which everybody assumes that there's asbestos there, and it's probably because of the degradation of the site and everything, then that friable material is probably within the community, and it's not one of the issues that we're really looking at, and I think it's something that the community should be looking at.
Is there medical monitoring provided? Does that community get monitoring of the medical condition of its citizens if they want it?
I think that in some of the communities there have been programs to try to bring something like that in.
Seems to me to be routine. It should be routine.
What's that?
It seems to me it should be routine.
Yeah,
it's an overlooked thing.
Again, it's only been a couple of weeks we've had any money, frankly. So we're kind of looking at a lot of the different options.
Got it.
Some of these community residents file claims in the Tronox bankruptcy. 12% of the money that came in is going to be going to those individual claimants for property damage as well as health issues. Unfortunately, a lot of the claimants didn't know, perhaps at the time, and maybe didn't file a claim. There's a procedure for filing late claims, but in the bankruptcy, it's probably not going to be terribly helpful. As far as asbestos goes, most of these facilities were taken down many years ago. Like I say, back probably in the 70s or 80s. The one site that we have standing, it's probably it's probably secured. It's just when it comes to dismantling, it's going to have to be appropriately done. We're very concerned with asbestos. I recently had a site where we had a criminal prosecution, 5 people that were taking apart a facility. I think 2 of them got 5 years, the other 3 got something between 1 and 5 years. And to answer your question a little bit, is that really egregious behavior is going to catch the attention of our criminal people. Hiring illegal aliens to bag asbestos material, paying them cash, going down to Home Depot and getting dust masks, Having people with chop saws cutting up the pipe will be asbestos material on it. That'll get you jail time.
And I think that's a great segue, because I'll tell you what, with that alone, we could probably take the rest of the day, which we were prepared to do. But with that, I'm looking at our professor. Thank both of you and all of you so much for this. Appreciate it so much for you guys. Thank you.